Agents working both sides of the transaction with no disclosure. Until recently, the real estate industry operated on a fundamental distinction between listing agents, responsible for properties on the market, and sub-agents, ostensibly working with buyers but actually representing the sellers. This model persisted nationwide for over a century, without significant challenge. In the late 1970s and early 1980s, many real estate professionals functioned on both sides of transactions, without disclosing to buyers or sellers whom we truly represented or how. Agency disclosure was a non-existent concept during this period, as our one-page purchase contracts did not address it, and there were no established rules or forms. This business approach endured from the mid-1890s to the late 1980s, during which there were two distinct roles: listing agents collaborating directly with sellers and buyers' agents seemingly working for buyers but acting as sub-agents of the sellers. Buyers often assumed they were working exclusively for them, even before they selected a property. However, the landscape underwent a significant shift. While sub-agency still lingers today as an option in our MLS, the industry has transitioned toward buyer representation over the past 3 decades. In contemporary real estate, when an agent works with a buyer, the agent typically represents the buyer, while the listing agent represents the seller, assuming they operate within different companies. Otherwise, they may function as dual agents. In 1984, the Federal Trade Commission criticized the lack of required disclosure in real estate transactions, particularly in dual agency situations involving agents licensed under the same broker or the listing agent selling to a buyer without representation. Consequently, states and the National Association of Realtors, NAR, began addressing agency disclosure, especially the challenges posed by dual agency. Hawaii led the way in 1985, enacting laws mandating written disclosure when a sale occurred within the same firm. Simultaneously, NAR established a task force that issued a 1986 report, A Realtor's Guide to the Law of Agency. From that point onward, various states implemented laws requiring some form of agency disclosure, although no federal action was taken. Between 1987 and 1990, states and real estate commissioners introduced rules and laws, prompting the emergence of exclusive buyer representation. During this period, brokers began abandoning sub-agency and embracing buyer representation, often seeking binding agreements with buyers, accompanied by non-refundable retainers and additional compensation clauses if the listing agent did not provide it. When you are working with a buyer or a seller or both, you must treat each with honesty. Confidentiality is the utmost value for your client, even past the close of a transaction. When you work with both the seller and the buyer in the same transaction, you must be so diligent in which hat you are wearing while working with each party. It is a tightrope walk sometimes, and you must be very careful. The real estate community faced a flurry of information, with state and national associations, along with real estate commissioners, disseminating guidance. Brokers and agents grappled with the complex shift away from sub-agency towards buyer representation and exclusive buyer representation. By the late 1980s, major metropolitan areas, including Phoenix, witnessed a surge in the adoption of buyer representation, particularly among large mega-brokers, setting the stage for widespread industry transformation. This is how the seller was responsible for negotiating a commission to the buyer's agent. It is all different now, as the seller is not responsible or obligated to pay any commission to the buyer's agent. We will get into that a little later. Licensee must disclose status in real estate transaction. Reviewed July 2019 facts. Jane, an agent licensed with ABC Brokerage Firm, lists her home for sale with XYZ Brokerage Firm. The XYZ agent did not place owner-agent on the XYZ brokerage sign in Jane's yard. Issue: does the XYZ brokerage yard sign need to say owner-agent? Answer: no. Discussion: under AAC R4 28502B, Any salesperson or broker advertising the salesperson's or broker's own property for sale, lease, or exchange shall disclose the salesperson's or broker's status as a salesperson or broker and as the property owner by placing the words owner-agent in the advertisement. Here, the rule does not require the XYZ agent to display an owner-agent sign on the XYZ brokerage sign because the property is not the XYZ agent's property. Note: Jane is required to disclose her licensing status at or before the time of the purchase contract. See AAC R4 28-1101. Therefore, the best business practice would be to disclose Jane's status as a licensed agent in the MLS and on the purchase contract. Reviewed March 2018 issue. Can a co-listing agent, who is a part owner and managing member of the selling entity, which owns the subdivision, also represent a prospective buyer of a property in the subdivision as a dual agent? Answer: no. Dual agency imposes restrictions on the conduct of the licensee. Among others, a dual agent may not advocate or negotiate on behalf of either the seller or the buyer. In addition, a dual agent may not disclose confidential information, such as the price the buyer is willing to pay to the other party without the informed consent of that party. Ordinarily, this is not a problem, and dual agency is in fact specifically authorized by Arizona law. See AAC R4 28-1101F. However, when a listing agent has an ownership interest in the property being conveyed, it would present a conflict for that agent to also represent the buyer. For this reason, an owner agent cannot also represent the buyer as a dual agent in a transaction. Facts: Broker A had a property listed 2 years ago. The sellers ultimately decided not to sell at that time, and the listing expired. 2 years later, the property is for sale with Broker B. Broker A has a buyer that is interested in making an offer on the property. Broker A knows that Mrs. Seller is ill, and this might be helpful in negotiations for his buyer. However, the knowledge was obtained while Broker A had the property listed for sale 2 years ago. Why must an agent disclose ownership of a property they are selling? An agent must disclose that they are a licensed real estate agent when selling their own home to comply with laws and ethical standards designed to protect the public. Here's why. 1. Duty of honesty and transparency. Real estate agents have professional knowledge and experience that give them an advantage in real estate transactions. Disclosure ensures fairness by making buyers aware that the seller is a professional who may have access to market knowledge, negotiation skills, and transactional experience that a typical seller would not. 2. Legal requirement. Most states, including Arizona, require licensed agents to disclose their license status when they have a personal interest in a transaction, including the sale of their own property. This is often part of the real estate regulations enforced by the state's licensing authority. For example, in Arizona Administrative Code R4 28-1101K, a licensee shall disclose in writing to all parties in a transaction any direct or indirect interest that the licensee has in the transaction. This includes being the seller or buyer in a transaction. 3. Code of Ethics, under the National Association of Realtors, R. Code of Ethics, Article 4. Realtors shall not acquire an interest in or buy or present offers from themselves, any member of their immediate families, their firms, or any member thereof, or any entities in which they have any ownership interest, any real property without making their true position known to the owner or the owner's agent or broker. That true position includes being a licensed agent. 4. Avoiding misrepresentation. Failing to disclose can be viewed as misrepresentation or concealment, which could lead to disciplinary action, civil liability, or even license suspension. How to disclose. Typically, agents disclose their license status in the listing and in the purchase contract using language such as, "Seller is a licensed real estate agent in the state of state." Previous listing agents still bound by confidentiality issue, can Broker A disclose the information to the buyer? Answer: no. Discussion. After termination of an agency relationship, the fiduciary duty is ended. See Coldwell Banker Commercial vs. Camelback Office Park, 156 Arizard 226, 231, 751, P2, 542, 547, 1988. However, pursuant to the restatement, second of agency, 1 Par 396, using confidential information after termination of agency, unless otherwise agreed, after the termination of the agency, the agent, D, has a duty to the principal not to take advantage of a still subsisting confidential relation created during the prior agency relationship. Therefore, Broker A's continuing duty of confidentiality to the seller after the listing expired would preclude him from disclosing the confidential information about Mrs. Seller even after termination of the agency relationship, unless Broker A obtains Mrs. Seller's consent.